Hello, ELPIS friends and scholars. My name's Akram Faizer. I teach law here at the LMU Law School in Knoxville, Tennessee, and it is my honor to make this presentation to you about the International Criminal Court. So I hope this will be useful to you, and I'm very honored to make this presentation. And I send my greetings and affection to everybody wherever you are. Okay. So some facts about the International Criminal Court. It has over 900 staff members from approximately 100 states. It has 6 official languages, right? English, French, Arabic, Chinese, Russian, and Spanish, kind of like the United Nations official languages. It has 1 liaison office to the United Nations in New York, 7 ICC country offices in Kinshasa, Congo, Bunia, the Democratic Republic of Congo, Kampala, Uganda, Bangui in the Central African Republic, Abidjan in Cote d'Ivoire, Tbilisi in the Republic of Georgia, and Bamako in Mali. It has 2 working languages, English and French. Okay. Its headquarters are in The Hague in the Netherlands. Its budget is a bit over 187 million euros, which is about $180 million. And there have thus far been 32 cases before the court, with some cases having more than 1 suspect. Okay. ICC judges have issued 49 arrest warrants, and thanks to cooperation from states, 21 people have been detained in the ICC detention center and have appeared before the court. 20 remain at large, and charges have been dropped against 7 people due to their death. ICC judges have also issued 9 summonses to appear. They have issued 11 convictions and 4 acquittals. So, with all these resources, there have been only 11 convictions. So what was created? It was created by the Rome Statute, right? It was established in Rome, Italy on July 17, 1998, and entered into force about 4 years later on July 1st, 2002. And it established 4 international crimes, namely genocide, crimes against humanity, war crimes, and the crime of aggression. So under the Rome Statute, the ICC can only investigate and prosecute 4 core international crimes in situations where states are themselves unwilling or unable to do so. Okay? The jurisdiction of the court is therefore complementary to jurisdictions of domestic court. What that means is, if there's a country, like by way of example, Rwanda, where there have been crimes against humanity, if Rwanda chooses not to prosecute or provides an amnesty, say it's Chile that does so, or Brazil, then the ICC has jurisdiction to commence prosecution. The court has jurisdiction over crimes only if they are committed in the territory of a party state, or if they are committed by a national of a state party. An exception to this is that the ICC may also have jurisdiction over crimes if its jurisdiction is authorized by the UN Security Council. Bear in mind, though, that's very unlikely to happen because, remember, there are 5 veto-wielding members on the Security Council, namely the United States, the Russian Federation, the People's Republic of China, the United Kingdom, and France. And quite often the countries that could be subject to an ICC prosecution or indictment will be protected by one of those great powers, right? So how was their jurisdiction over Ukraine? The reason is, even though Ukraine was not a signatory to the ICC, as we'll discuss later, Ukraine, right, has twice exercised its prerogatives to accept the court's jurisdiction over alleged crimes under the Rome Statute. So in other words, even though Ukraine is not a signatory, it in 2014 allowed the ICC and subsequently after 2014 to have jurisdiction, largely to help police against crimes against humanity and crimes of aggression brought by the Russian Federation against Ukraine. Okay. The other problem in Ukraine, as we'll discuss soon, is the kidnapping of children by the Russian Federation, okay, of Ukrainian children. So let's look at the Rome Statute. Article 1 says, the court is an international court is established. It shall be a permanent institution and shall have the power to exercise its jurisdiction over persons for the most serious crimes of international concern as referred to in the statute, and shall be complementary to national criminal jurisdictions. The jurisdictions and functioning of the court shall be governed by the provisions of this statute. Okay? Article 2 provides that it shall have a complementary relationship with the United Nations. Okay? Article 5, I'm skipping ahead just to the most important ones, says that the court shall be limited to the most serious crimes of concern to the international community as a whole. The court has jurisdiction in accordance with the statute with respect to the following crimes: genocide, crimes of humanity, war crimes, and the crimes of aggression. And kind of bearing in mind that was not a crime of genocide at the time of the Nuremberg and the Tokyo trials, right? There has since been an international jus cogens norm against genocide, which we see in this statute. Okay? So what is genocide? And so for purpose of this statute, genocide means any of the following acts committed with the intent to destroy in whole or in part a national, ethnical, racial, or religious group as such. And that includes with intent to destroy, killing members of the group, okay? Causing serious bodily or mental harm to members of the group, deliberately inflicting on the group conditions of life calculated to bring about its physical destruction in whole or part, imposing measures intended to prevent births within the group, okay? Forcibly transferring children of the group to another group. That's the one we talked about, what Russia's doing with Ukraine, right? With respect to crimes against humanity, with respect to crimes, for purposes of the statute, crimes against humanity means any of the following acts when committed as part of a widespread or systematic attack directed against a civilian population, okay? Which includes murder, extermination, enslavement, deportation, or forcible transfer of populations. Okay? Okay. Now, crimes against humanity, right? They include imprisonment or other severe deprivation of physical liberty in violation of fundamental rules of international law, right? Torture, which we all know is a jus cogens norm. Rape, by way of example, what Hamas and the Hamas terrorists appeared to have done in Israel. Sexual slavery, enforced prostitution, forced pregnancy, enforced sterilization, or any other form of sexual violence of comparable gravity. Persecution against any identifiable group or collectivity on political, racial, national, ethnic, cultural, religious, gender as defined in paragraph 3, or other grounds that are universally recognized as impermissible under international law in connection with any act referred to in this paragraph, okay? So that's Article 7. Article 8 talks about war crimes, which are grave breaches of the Geneva Conventions of August 12, 1949, namely any of the following acts against persons, property, under the provisions of the relevant Geneva Convention. Torture or inhumane treatment, including biological experiments, right? Willfully causing great suffering or serious bodily injury, extensive destruction and appropriation of property not justified by military necessity, compelling a prisoner of war or other protected person to serve in the forces of a hostile power, and willfully depriving a prisoner of war or other protected person of the rights of fair and regular trial. Unlawful deportation, right? Or transfer of unlawful confinement, and then the taking of hostages, right? So look, we see this, why people could get in the crosshairs of Article 8. By way of example, the United States, I think, legitimately was alleged to be torturing detainees in a whole host of sites, but as well at Guantanamo Bay in its war against terrorism. And we see within the Hamas case, the taking of hostages, right? The crime of aggression. For the purpose of the statute, the crime of aggression means planning, preparation, initiation, or execution by a person in a position effectively to exercise control over or to direct the political or military action of a state of an act of aggression which, by its character, gravity, and scale, constitutes a violation of the Charter of the United Nations, right? And the argument could be made, work with me here, right? That the United States decision to commence a war against Iraq without Security Council authorization could well be characterized as a crime of aggression if the United States had been a signator to the Treaty of Rome, right? Article 16, right, provides for the deferral of investigation or prosecution. It says that no investigation or prosecution may be commenced or proceeded with under the statute for a period of 12 months after the Security Council, in a resolution adopted under Chapter 7, has requested the court to take to that effect. Once again, that's unlikely, right? Because of the divisions amongst the three most important members of the Security Council, namely the United States, Russia, and China. Increasingly, Russia and China, as you all know, seem to be allied, especially in the case of the war of aggression against Ukraine, with the United States on the other side. The flip is, of course, the United States has the entire liberal international community on its side in opposing this war. Article 34 provides, right, the court shall be composed of the following: a presidency, an appeals division, a trial division, and a pretrial division. It has an office of a prosecutor and a registry, which is basically its staff members. Article 40 talks about the independence of judges. And basically, I won't go into the text necessarily, but it basically assures that we elect highly qualified and independent judges. Okay? So let's talk about a bit of the background, right? The UN General Assembly Resolution number 260 of December 9, 1948 provided for a convention on the prevention and punishment of the crime of genocide. Right? It was the first step toward the establishment of an international permanent criminal tribunal with jurisdiction on crimes yet to be defined in international treaties. In the resolution, there was a hope for an effort from the legal UN Commission in that direction. So it started off, right? Think of the catastrophe that befell your continent, your great, wonderful continent of Europe, the great European homeland you live in now. But there was a catastrophe that befell Europe from 1939 to 1945. And the UN General Assembly was trying to deal with that catastrophe, right? And that explained the startings of the whole international system with the Genocide Convention. But it progressed further, right? There were conventions against torture, right? So in 1989, we go further, and the nation state of Trinidad and Tobago asked that the General Assembly to reopen the talks for the establishment of an international criminal court, and in 1994 presented a draft statute. So the General Assembly in turn created an ad hoc committee for an ICC, and after hearing the conclusions, a preparatory committee that worked on the draft for 2 years from 96 to 98. Okay? And this, of course, was well on the heels, of course, of the two major catastrophes of the post-Cold War era in terms of the laws, the human rights catastrophes. The most obvious one, of course, is the genocide in Rwanda in 1994, and the other one, of course, is the war that followed the crimes of aggression brought by Serbia and to a lesser degree Croatia against the people of Bosnia, right, after the collapse of Yugoslavia. And the fact is, there were two tribunals set up, right? The International Criminal Tribunal for the former Yugoslavia and the International Criminal Tribunal for Rwanda, right? The UN's International Law Commission considered the inclusion of the crime of ecocide to be included within the draft code of crimes against the peace and security of mankind, right? Which became the law, the Rome Statute, right? It was publicly supported by 19 countries in the legal committee, but was removed due to opposition from the Netherlands, right? The United Kingdom and the United States. Most likely, I'm guessing the echo side, not guessing, but the evidence is the Netherlands uh, opposed this because, of course, the accusations brought against Royal Dutch Shell, the petroleum company, about how it carries on its activities in sub-Saharan Africa. The United Kingdom, of course, with British Petroleum, and the United States for a whole host of reasons. Okay. During its 52nd session, the General Assembly decided to convene a diplomatic conference to finalize and adopt a convention on the establishment of an international and criminal court. It was convened in Rome from 15th of June to the 17th of July 1998 and was attended by representatives from 161 member states. I think it's important that we get an idea of this time frame, right? The world economy was doing very well. There was relative peace and prosperity, bearing in mind the traumas, of course, of what happened in Rwanda and Yugoslavia, with an idea that it was never again, was the idea. Problematically, though, there were problems that the international community was not recognizing. I think one of the major ones was the continued problems in the former Soviet Union, and the reality that there was not adequate, and the fact that there were not adequate resources being provided to ensure a proper democratization of what was the Russian Federation, so that it could feel secure. I think one of the things we might look at too is, in this framework, as Russia was very weak and poor at this time, there was also the expansion of NATO going westwards, and the expansion of the European Union to the member states of the former Central Europe that were part of the Warsaw Pact countries. Okay. There was no official record of each delegation's vote, but it was adopted by a vote of 120-7, with 21 countries abstaining. Right, so there was an overwhelming consensus in favor of the Treaty of Rome. But the problem is, look who's voting no, right? The People's Republic of China voted no, and can we all agree that is not a minor country? Israel, right, which is the most powerful military country in the Middle East, voted no. And the United States, the most powerful country in the international system, voted no, right? They have publicly confirmed their negative votes, and countries like India, Indonesia, Iraq, Libya, Qatar, Russia, Saudi Arabia, Sudan, and Yemen have been identified by various observers as possible sources for the other 4 negative votes, right? With Iraq, Libya, Qatar, and Yemen being the 4 most commonly identified. Explanations of vote was publicly declared by India, Uruguay, Mauritius, Philippines, Norway, Belgium, the United States, Brazil, Israel, Sri Lanka, China, Turkey, Singapore, and the United Kingdom. Okay? So now we go forward, right? The United States is a no. So we have the ICC set up, but arguably the country that's unequivocally the most powerful country in the international system, the United States, has voted no to its creation. It's not a member. Okay. And China, which right now is by a wide margin the second most important country in the international system, is not a member as well. So on April 11, 2002, 10 countries had ratified the statute at the same time at a special ceremony held at the United Nations headquarters in New York City, bringing the total number of signatories to 60, which was the minimal number required to bring the statute into force, as defined by Article 126. The treaty entered into force on July 1, 2002, and it can only prosecute crimes committed after that date. The states parties held a review conference in Kampala, Uganda in 2010, and it adopted a definition of the crime of aggression, thereby allowing the ICC to exercise jurisdiction over the crime for the first time. It also adopted an expansion of the list of war crimes. Amendments to the statute were proposed to implement these changes. Okay? So let's talk about the United States, of course, which is the country that I am a citizen of and live and work in, and where I teach law. And President Clinton, right, in 1998, the Clinton administration refused to sign on to the ICC. Before he left office on December, there's just 20 days before he left office, he signed the ICC treaty, but expressed concern that it could threaten American sovereignty and implicate American service members overseas, right? I think the key thing to be mindful of is the United States, by and large, is the only major country in the international system that deploys troops worldwide, right? But he never submitted the treaty to the US Senate. Under the US Constitution, all treaties need the approval of 67 of 100 senators to become the supreme law of the land. And so though he signed it, he never submitted it to the Senate for ratification, most likely because he knew it would fail in the Senate. Now, not long after that, September 11th happens, the Al-Qaeda terrorist attacks on the United States, and the United States begins the war against terror. We call it here the War on Terror. And Clinton's successor, George W. Bush, sent a note to UN Secretary General Kofi Annan, stating the United States would not ratify the Rome Statute and did not recognize any of its obligations. Going further, the United States goes even further, and it enacts the American Service Members Protection Act, right? A bill to protect U.S. military personnel and other elected and appointed officials of the United States government against criminal prosecution by an international criminal court to which the United States is not a party, right? And this is being codified in U.S. law. And it gives the U.S. president power to use all means necessary and appropriate to bring about the release of any U.S. or allied personnel being detained or imprisoned by, on behalf of, or at the request of the International Criminal Court. Okay? How would this apply? It would mean, for example, that no other country could seek to enforce an ICC provision against a U.S. serviceman, right? The U.S. would fight that. And then the U.S. sought bilateral immunity agreements at the same time. In other words, agreements with other countries that they would not cooperate with the ICC when dealing with U.S. personnel, okay? And that was another thing, right? Because Article 98 of the Rome Statute prohibits the ICC from requesting assistance or the surrender of a person to the ICC if to do so would require the state to act inconsistently with its obligations under international law or international agreements, right? Unless the state or the third party waives the immunity or grants cooperation. And so the US has interpreted this article to mean that its citizens cannot be transferred to the ICC by any state that has signed a bilateral agreement with the US prohibiting such a transfer. Okay? And then there were Security Council resolutions, right? And so in 2002, right, I think this is probably at the peak of the Bush administration's power, because remember, July 2002, the United States had not yet commenced its misadventure in Iraq. And the Bush administration had at the time, things seemed to be going well in Afghanistan, and there was the United States seemed to have the international community behind it in prosecuting its war on terror. But the United States threatened to use its Security Council veto to block renewal of the mandates of several UN peacekeeping operations unless the Security Council agreed to permanently exempt US nationals from the court's jurisdiction. The Secretary General of the United Nations at the time, Kofi Annan, was Ghanaian, said that the US proposal flies in the face of treaty law. Okay? A resolution to exempt citizens of the United States from jurisdiction of the ICC was renewed in 2003 by UN Security Council Resolution 1487, right? However, the Council refused to renew the exemption again in 2004 after pictures emerged of US troops torturing and abusing Iraqi prisoners in the Abu Ghraib prison in Iraq. Okay? So we can see, therefore, that the United States not only initially didn't sign on, but has taken a very hostile approach to the ICC. Okay? And this is a list. There are 124 signatory countries here to the ICC. I have a list here. Basically, all the Western European countries of the ELPIS members and the Central European countries are members of this. Some countries we see, for example, South Africa, it signed in 2000, it withdrew in 2000, and then it sought membership again, right? Um, and it's rejoined. I think some importantly, many of the countries that have had histories of things like torture and problems, such as Argentina and Chile, are members, as we see, right? And many sub-Saharan African states have been members. I think one thing that might be looked at is many sub-Saharan African states have become members because of pressure from the international community that the international community cannot exert on countries like the United States. Okay. So these are the 124 signatories, right? They include, of course, countries that, of course, obviously have suffered international crimes like Bosnia-Herzegovina, the Democratic Republic of the Congo. We all know, of course, the genocides committed in Cambodia under the regime of Pol Pot, right? And of course, it includes the list of countries that are considered outstanding international citizens and important countries in this hemisphere, right? Such as Brazil, okay? And so those are the 124. The most recent one is Armenia in November 14, 2023. And that most likely has something to do, the timing of that, with the Russian invasion of Ukraine. Okay. Notice another one, Palestine is a member, is a signatory, but there is no Palestinian member state that is recognized under international law. In other words, what we call the state of Palestine is basically an area of where Palestinians live under occupation of the Israeli military, either de facto or de jure. Okay? Look at the non-signatories. There are 69 non-signatories. These are the most important ones from my perspective. Of course, the United States, but China and India. So two most populous countries. The most powerful country in the international system is not a member, and the two most populous are not a member, right? Indonesia, which is the most populous Muslim country in the world, is not a member. Israel, as I said, the most powerful country in the Middle East militarily and in terms of high tech and human capital, is not a member. The Philippines withdrew in 2019. Sri Lanka, which is the country of my ethnic origin, is not a member. That makes a lot of sense because Sri Lanka has committed many crimes against humanity against its Tamil minority. Saudi Arabia, which is the most resource-rich Arab country, is not a member. Turkey, which is a NATO member and a Middle Eastern and European state, is not a member. And of course, Ukraine is not a member, bearing in mind, though, it has now agreed to the ICC having jurisdiction on its territory. Okay? So the ICC has adjudicated 32 cases thus far. All were brought, though, against individuals from sub-Saharan Africa or North Africa. So if you look at the pictures, it almost looks like it's a dystopian presentation of racial bias if you look at who the prosecutions are brought against. It has commenced cases against 58 defendants. All were brought against sub-Saharan and North Africans, except one brought against a North Ossetian from the Republic of Georgia seeking to have Russia annex North Ossetia from Georgia, and 7 against citizens of the Russian Federation, including, of course, President Vladimir Putin and former Defense Minister Sergei Shoigu. Okay. It also has brought applications for arrest warrants against Hamas. We all know on October 7th, Hamas commenced a inhumane, murderous attack against Israelis, innocent Israelis, that led to 1,300 plus Israelis being murdered, many being systematically raped, and of course, many being kidnapped and brought back and held hostage to this very day in the Gaza Strip. And so the ICC brought applications for arrest warrants based on the Israel-Gaza war against Yahya Sinwar, head of Hamas, Mohammed Diab Ibrahim al-Masri, more commonly known as Daif, right? And Ismail Hania, who, of course, was killed yesterday, July 30th, most likely by the Israeli Mossad. He was living in Tehran, and the Mossad, of course, had him killed. They're also, and the charges brought against them were extermination as a crime against humanity, murder as a crime against humanity, taking hostages as a war crime, contrary to Article 8, rape and other acts of sexual violence, torture, other inhumane acts as a crime against humanity, cruel treatment as a war crime, and outrages upon personal dignity as a war crime. Okay? But the ICC, though, went further. It didn't just bring charges against Hamas, it brought charges after Israel commenced a military operation that has seen close to 40,000, as of this date, Gazans suffer terrible conditions, mass killing, lack of food, lack of medicine, a very, very inhumane military action by the Israeli government against the Gazans. They brought charges against Prime Minister Benjamin Netanyahu, who was a long-standing Israeli politician that you all know, and his defense minister, Yoav Gallant. Okay? And these are the charges in the application for arrest warrants brought against these two Israeli officials. Starvation of civilians as a method of warfare, willfully causing great suffering, willfully killing, right? Intentionally directing attacks against the civilian population, extermination and or murder contrary to Article 7, 1B and A, persecution as a crime against humanity, and other inhumane acts as crimes against humanity. Okay? But as we know, for example, this has not resulted in anything beyond that. The US is not a signatory to the ICC, right? And of course, as we know, Netanyahu visited Washington recently and gave a speech to Congress, and no one even raised the issue whether he could be delivered and transported to The Hague in that situation. We know, for example, also that President Putin has been formally indicted by the ICC, and Putin, the South African government, made no bones about it when it said it would not, should Putin visit South Africa, though it's a signature member, would not arrest Putin for purposes of transporting him to The Hague. So we see, for example, the ICC system tends to work against weak states without any political backing in the international system. The moment states have backing and power, the ICC system seems to break down. So what about the United States, right? The US is not a signatory to the ICC. Beyond that, the Hornbook understanding of US constitutional law was that sitting presidents are immune from criminal indictment and prosecution while in office. What about after they leave office? And so this is what the US Constitution says, that judgment in cases of impeachment shall not extend further than to removal from office and disqualification to hold and enjoy any office of honor, trust, or profit under the United States. But the party convicted shall nevertheless be liable and subject to indictment, trial, judgment, and punishment according to law. That seems to mean, by implication, from my reading, that a president, upon leaving office, either by removal via impeachment and conviction or just leaving office, can be subsequently criminally prosecuted. And that was always the understanding. And it was the understanding outlined in a 1974 Office of Legal Counsel memo at the US Department of Justice. And it was reiterated in the Mueller report looking into Russian interference in the 2016 American presidential election, when former FBI Director Mueller, who was the special counsel charged with the matter, in his report said that former President Trump could always be prosecuted upon leaving office. But the United States, in a decision that came out this June called Trump v. United States, right, said otherwise, right? And so let's look at the facts here. A federal grand jury indicted former President Trump on 4 counts for conduct that occurred during his presidency following the November 2020 election, the election that he lost to President Biden. The indictment alleged that after losing that election, Trump conspired to overturn it by spreading knowingly false claims of election fraud to obstruct the collecting, counting, and certifying of election results. Trump moved to dismiss the indictment on presidential immunity, arguing that a president has absolute immunity from criminal prosecution for actions performed within the outer perimeter of his official responsibilities, and that the indictment allegations fell within the core of his official duties. This was rejected by the lower courts, okay? And the lower courts made the dismissal because they basically said a president is not immune, right, for such an act, and is not immune upon leaving office, right? But the Supreme Court reversed, and this is what it holds in a decision issued by the Chief Justice, John Roberts. He writes that under our constitutional structure of separated powers, the nature of presidential power entitles a former president to absolute immunity from criminal prosecutions for actions within his conclusive and preclusive constitutional authority. And he is entitled to at least presumptive immunity from prosecution for all his official acts, okay? There is no immunity from unofficial acts. In other words, if a president, for example, is caught with a pistol shooting the butler at the White House, that can be prosecuted after he leaves office because that's an unofficial act, clearly. But for anything else that's sort of an official act, including acts that seem obstructive, such as this, communicating with state officials to try and suppress the vote, there's a immunity that's granted, which you could argue is problematic. I think the fundamental rationale they give for this is the concern that we could, in the United States, devolve into a situation like a Pakistan situation, where the moment you leave office, you're prosecuted or thrown in jail. And that would not be healthy from the United States as far as the Supreme Court's concerned, right? And they write the nature of presidential power requires that a former president have some immunity from criminal prosecution for official acts during his tenure in office. And they write that appreciating the unique risks that arise when a president's energies are diverted by proceedings that might render him unduly cautious in the discharge of his official duties, the court has recognized that presidential immunities and privileges rooted in the constitutional tradition and supported by our history, right? So to give you an example, President Obama, you could argue, violated the international law when he authorized, without any legal process, US drones to be used to kill an American citizen in the Yemen, a man by the name of Anwar al-Awlaki, right? The concern, the court says, we wouldn't want a president to worry about being subsequently indicted making that decision, right? The court concludes that the separation of powers principles explicated in the court's precedent necessitate at least a presumptive immunity from criminal prosecution for a president's acts within the outer perimeter of his official responsibility. And as for unofficial acts, by way of example, caught with a pistol, shooting the hotel, shooting your butler in the White House, there is no immunity. That's what the court holds. But this is problematic because the court is sending a message to the international system that while, it's worthy of prosecuting people from developing nations or smaller countries, the country that's the most important country in the international system, the most powerful one, its leaders can't be prosecuted. I think that sends a problematic message of presidential immunity, a message basically that might makes right, which I think we all figure the whole purpose of international law is to get around that, right? And so the United States not only has done this, but its constant movements against the ICC are particularly problematic, right? And it kind of contradictorily, it may be too strong a word, but it has supported ICC indictments brought against Russian officials, including President Putin, but it has ridiculed those that are mooted against Israeli leaders. And so the risk for the US is that it can be seen to be rejecting international norms in favor of power politics that subordinate those norms to US domestic politics. And the question is for the ICC, is this system going to be able to continue as other countries might start adopting the US position, right? So for example, it's very plausible, for example, that a country like Germany, let's work with me here. If an indictment is brought against Netanyahu, most likely Germany wouldn't cooperate with the ICC should Netanyahu visit Berlin, right? Because the importance the Federal Republic of Germany attaches to its relationship with Israel. And so those are the kind of things we could see a collapse of the ICC framework under the current system where the great powers are not getting along and acting with impunity themselves. Okay. Well, thank you for paying attention to me. I hope this has been useful, and I'm very, very honored to have done this. Thank you. Take care.